Good morning, everyone. Thank you for joining us today for the 2025 Legislative Update webinar. My name is Ashley Merritt, and I'm the General Counsel and Communications Director for the agency. Just a few housekeeping items before we start. We will be taking questions. If you could submit those in the question and answer box. Melissa will be reviewing those throughout, and we have reserved 30 minutes at the end for questions, which we will address. And then secondly, for those that are seeking to obtain credit hours for continuing legal education, we will drop the CLE form in the chat shortly. It is also on our website on the webinars and trainings page. And there will be two code words throughout the presentation, so I will be interrupting Chris and Colin for those. But for now, I'll kick it over to Chris Sarek.
Right. Thank you very much, Ashley. I am Chris Sarek. I'm the Deputy Director, Executive Secretary for the Indiana Alcohol and Tobacco Commission. And we have the full legal team here from ATC. That's Ashley Merritt, our General Counsel, our Senior Attorney, Melissa Beaucaire. And then we also have our Chair, Jessica Allen, participating this morning, and Colin Davis from DOR. He is the Director of Tax Policy over there, and we are very fortunate to have a great partnership with our agency partners at DOR. And he's going to speak some today about the legislative changes impacting taxes that have to do with our industry. So Ashley, I don't know if you can get that PowerPoint going, and I'll start my presentation.
Absolutely. Let me pull it up. Go.
And while she's doing that, I'll just give a brief introduction to the legislative session. It was a very busy session for us at the Alcohol and Tobacco Commission. I think that's probably true for all of our agency partners and everybody in every industry in the state of Indiana. It's just been a very productive and busy time. So that's a good thing, I think. We're seeing change in Indiana, and it's all positive, which is always fun to see and interesting as a public servant to participate in. While we didn't get all of our priorities done, we did get the vast majority of what we were looking for across the finish line. And a lot of the credit for that goes to our industry partners who were engaged throughout the session, always bringing things to me to look at and to try to collaborate with their cohorts and other aspects of the industry to find the middle ground, to find the collaborative outcome. And that's the best way to make policy, the best way to make law. So I think that's why you see some good outcomes here for both the industry and for the agency in terms of filling in some regulatory gaps, doing some deregulation, making some cleanup technical and modernization changes, but also providing some new privileges and permitting opportunities for the industry to be a little bit more inventive and imaginative with commercial opportunities. And I think that's a great thing. We are looking forward to the summer to continuing to work with all of you in the industry, getting together at board meetings, at seminars, just having informal sit downs. All of that is extremely valuable for us to continue fostering and growing our partnerships with you all in the industry. And then going into next session, I hope we have a robust set of proposals that have been vetted and are ready to go come January of 26. So with that, I'm going to get started in substance here.
Okay, can you see the slideshow? Wait.
I see your background now, but I did see the slideshow.
Hold on.
There, you got it. I see it. All right. They have changed teams. So every time we do a webinar, it's got a little bit more tools, and that's a great thing, but it does make it a learning curve a little bit as we get started here. So we'll get going here to the next slide. And here's our legal disclaimer. It is important for me to make this legal disclaimer. All of the information today is for informational purposes. As an attorney and as an agency leader and a state employee generally, I cannot give you legal advice. I can't direct you as a permit holder, as an attorney, as an industry stakeholder representative, what to do under the law. I can, of course, give you guidance as to what the law says, but it is up to you to consult with your attorneys to figure out what is the best and most legal course of action to take under any given circumstance. That being said, of course, we're here to answer your questions and to let you know what the law says and how we interpret it. But again, it is important to make that disclaimer. Any pictures that are in here are fair use. I don't think there actually are any this year, except for that cheesy comic strip. So I'm going to start with the alcohol and tobacco legislation, and then I'll kick it over to Colin to do the DOR stuff, the revenue related stuff. I will note that this table is all inclusive. Every single bill is linked. There's 4 of them. They're pretty big though, especially 1275. That bill number is itself a live link to the General Assembly's webpage with the latest version of the bill. So if you use this PowerPoint as a resource, you can link to those bills directly right there. I was going to go through and link every single code site to the IGA code table, but that probably isn't a good idea because those things change. So I didn't do that, but I did at least provide you links to those bills. And I'm going to go through each one of these in the order here, the sequential order provided. So I'm ready for the first bill here. This is HEA 1053. This bill is actually, if you were involved in the legislative session, you know that this bill is a combination of a Senate bill and a House bill that were put together in conference committee to make HEA 1053, which was never a bill number that was an alcohol tobacco bill until conference committee. So this has some gaming provisions in it in addition to the alcohol tobacco stuff. And I'm not going to talk about the gaming stuff. You can talk to Dennis Mullen over at the Gaming Commission if you have questions about that stuff. Those provisions, though, that are related to gaming are effective immediately. Those are emergency effective dates. Everything else in the bill is July 1, 2025. This bill creates some new non-quota permits. It creates some parity in the delivery privileges for wine dealers. Provides us a little bit of emergency authority, and updates artisan distiller permit scope, and makes a change to the DORA ordinance requirements. Ready for the next? Thank you very much, Ashley. So the new permits, there are 4 new non-quota economic development permits. Anybody who's been around for at least a year knows that 16.8 is the landing spot for most of our new jurisdiction-specific non-quota permits. These are economic development permits, and we've got 3 new ones for the city of Warsaw and 1 for the town of Syracuse. Non-academic development district permits are $40,000. They are non-transferable except for ownership if the location is no longer an economic development area. And they're 3-way restaurant permits. And again, they're non-quota and they have to be in economic development districts as determined and established by the locality. The new Syracuse permit is the exact same thing as the Warsaw permit. So those permits are available if you're in that jurisdiction and you fit the requirements, then let us know that you want to apply. Next slide. The wine delivery change. This is something that has come up a couple of sessions consecutively. And all this really does is create parity in wine dealers, the same rights that the other dealers had prior to this. And it allows wine dealers to deliver wine via an employee with an employee license to the home, residence, or other designated location of the customer. So if you're a wine dealer, you have a wine dealer permit, you can now deliver wine to the home, office, or designated location of one of your customers. This again creates parity. It's not really a new privilege, except for to the extent that it gives the same privileges as other dealers had now to wine dealers. The notice of suspension of revocation hearing. So early in the session, we had a bill, ATC, well, it wasn't our bill, but there was a bill brought that impacted ATC that gave us emergency authority to essentially suspend or revoke a permit before a hearing. And then notice would be provided, and then the hearing would occur, and we would determine if the revocation or suspension was appropriate. That didn't get a lot of traction in the House, and so it passed the Senate, and then it expired in the House. And of course, we understand there are varying interests in that. And so as sort of a compromise to make sure that the ATC at least has authority to bring matters quickly that have emergency circumstances, we shortened the notice period from 10 days to 3 business days. So all of this means is that now the Alcohol Tobacco Commission, if we catch wind or have information about and begin an investigation regarding a permit holder where there are emergent circumstances, there's a risk to public safety, we can give notice and then have a hearing with after 3 business days. So if we gave notice on Monday, we could have the hearing on Thursday. If we gave notice on Thursday, we could have the hearing on Tuesday. So the idea being that we don't have to inherently wait a full week and a weekend before a hearing can occur if there's an emergency circumstance. So this doesn't create any new authority for the ATC. All it does is shorten that notice period to 3 business days rather than 10. And I will note that this is very specifically and intentionally business days, such that if we gave notice on a Friday, Saturday, Sunday, those don't count in determining those 3 days. So that hearing could not occur until the following Wednesday. So I don't see us using this very often. We don't have a lot of suspension and revocation hearings as it is under these circumstances. So we have a very cooperative and collaborative industry. So I don't anticipate us needing this. And I ask for your help in making sure that my optimism comes to fruition. In terms of the DORA cups, this is a really minor change. Another one I don't see impacting a lot of you out there. However, the law now provides that a municipality in its ordinance or in any other capacity cannot dictate to a DORA designated vendor where they buy their cups. So the town of A can't require that the DORA participants buy their cups from cousin Jim at Cups R Us. That is now violative of the law, and you can't do it. So I'm not sure it was happening before, but it's definitely not going to happen now. Let's get to the next slide, please. This is the artisan distiller changes. So this is, I think, significant for our artisan distillers out there, and a great industry segment. I really enjoy working with you guys. You came to the legislature and to the ATC well in advance of this session. We had lots of meetings last summer regarding some of your concerns and wishes and desires regarding your scopes of permit. I think we found some middle ground in terms of what the legislature had an appetite for, and we end up with a maximum production cap increase from 20,000 gallons of liquor a year to 30,000. So that's a 10,000 gallon increase. Now artisan distillers can produce up to 30,000 gallons of liquor per year. I'm not sure if there are any permit holders that are approaching that cap. If you represent a permit holder approaching the cap and you want to reach out and talk about any concerns that you have, please feel free to do so. This bill also increases the self-distribution cap for those artisan distillers who are distributing their product themselves directly to retailers. There are obviously limitations on who can directly distribute to retailers as an artisan distiller. It's limited to just artisan distillers that do not sell to a wholesaler and that distribute less than or equal to 10,000 gallons per year in Indiana. So this gap of 10,000 was increased from 9,000, and the volume of self-distribution is now 2,000 gallons. So previously, a artisan distiller that meets the qualifications stated under the first bullet point, they could distribute directly to retailers up to 1,000 gallons of liquor. Now they can just self-distribute up to 2,000 gallons of liquor. And so, again, I think this is a positive change for the industry and something that was necessary to help some of our artisan distillers grow in what is an emerging marketplace. Another new privilege and this is a new privilege, I should say, for the artisan distillers is collaborative distilling. This same privilege was given to our craft brewers last session in 2024. And it effectively allows an artisan distiller to contract with another artisan distiller to produce liquor on behalf of the first artisan distiller. So permittee A enters into a contract with permittee B and says, hey, can you produce 5,000 gallons of liquor for us? That would probably be a lot, but produce 5,000 gallons for liquor of us under contract. The other distiller agrees. They can produce the product, ship it back to the first artisan distiller, and that distiller can then distribute via the wholesaler or direct retail if that's a privilege that they're allowed. Based on conversations I've had with industry members and stakeholders, I'm not sure how often this will be used, but I do look forward to learning more about opportunities out there for this arrangement to be utilized. There are some limitations imposed on the exercise of the privilege. First off, the distiller for whom product is manufactured, they have to self-produce at least 40 gallons from raw materials on their licensed premises before they're able to exercise this contract distilling privilege. In addition, the distiller who does the manufacturing, they have to manufacture more product for themselves from raw materials on the licensed premises than they do for another distiller under contract. Idea being here that you don't set up sort of a shell distiller where all you do is you don't produce anything of your own. You're not an artist in the sense that you develop your own recipes and products. All you do is contract to distill for other people. You essentially act as the manufacturer, but not really the artisan component. So that's avoided by requiring that the contracting or the individual who's contracted to make the product has to produce more for themselves than they do for somebody else. And now we are on to HEA 1275. HEA 1275 was our agency bill. It is a very large bill, made a lot of changes. You probably noticed in the index that there's a lot of code sites that are referenced. And I've got bullet points here that go through each and every change that was made. Rather than recite those to you, I'm going to actually go through the slides and I'll talk about each one as we get to the slide. However, if you are using this as a resource, you can go back and jog your memory. Hey, what's in HEA 1275? And this hopefully will be somewhat helpful for you in remembering that. There are two emergency effective dates that we'll get to later. One is fee waived extensions, and the other is the ownership disclosure modernization. I'll explain those items here in a minute, but those are both in effect today. So starting out with some more house cleaning type items, not entirely house cleaning. Some of these have substantive impacts for sure, but they're not new code sections or privileges. So with regard to modernizations, we have repealed the registrations of formula brands, other intellectual property. Previously, it was required that information be recorded with the ATC, registered with the ATC. That statute has been repealed, no longer required. Wasn't something that was being utilized. And the ATC, we try very hard to identify areas of the law where if we're not exercising a piece of authority or imposing it, or if we're not actually utilizing information that we've required to be provided, we're going to get rid of the law because it doesn't make sense to impose a requirement that's not actually bearing any fruit in terms of good public policy outcomes. The local board minutes are now able to be produced electronically. This is more of an internal thing, but we can now receive local board minutes instead of paper via electronic submission, which is very nice. There's also some cleanup in the language used for local boards to make it consistent with how the rest of Indiana code refers to like an individual human. Instead of using gendered language, it uses more neutral language. That type of LSA, Legislative Service Agency type cleanup item. The next modernization, I think this is one that's going to benefit our permit holders. We now have, if you have a subsequent extension, so your first extension, is free as long as you meet the extension requirements. However, under current law, you had to pay for any subsequent extension. So we have introduced a fee waived subsequent extension where the reason for the extension is the fault of the ATC. Let's say that a processor got busy and it got moved to the back of their queue on accident and they didn't get to it before the deadline and there was going to be an expiration. We can give a subsequent extension there without charging any fee to the permit holder. If it's the fault of a third party, it can also accrue a fee waived extension for the permit holder. And again, this is in effect now. So if you're running into a situation where there's a delay in processing your permit and it's the fault of the ATC that you are about to expire, then you can get a subsequent extension fee waived. The next modernization kind of relates to that first repeal of the registration of IP, and that is repealing the keg registration program. So I'm sure everybody who is a dealer anyways that sells kegs is familiar with the keg registration requirements. Those have been repealed. So you no longer have to register your kegs and buy those paper slips that fall off of the keg anyways when it gets wet, that you can't read. The many problems that we all know exist with this paper keg registration. It was a great idea. And in theory, it was going to decrease sales to minors and maybe help ATC track the source, or excise more of, track the source of unlawful sales to minors via these keg registrations. Wasn't being used that way because it really didn't work logistically. So we've just repealed the statute. That means that all of the IAC code provisions, the rules are also now moot and will be sunset. The next update is a special disqualification update, not a substantive change. It's just a change to the words used. So current law, we say that you can't be an alien and be a permit owner. The term alien is not utilized in Indiana code. We use the term legal status. So the update essentially just says that the owner has to have legal status. And legal status is any right to be here in the United States and to work in the United States. That is legal status. It's defined in another code section that is referenced in the special disqualification code section. So that is a change. How you'll see that manifest on applications. Our applications actually currently say citizen. So the new and transfer and renewal dealer, retail, and manufacturing and distributor permits, they all say citizen. It should actually say alien currently, but it's going to be updated from citizen to has legal status. So you'll see that change. It's not a substantive change, so don't worry about it. It's just a term of art change. We have also opened up electronic participation to charity auctions and raffles. This doesn't impact type 2 gaming. This just means that if you go to a charity auction, let's say at your kid's school, and you have a raffle there or a charity auction, you can participate via an electronic app. It's usually an app. I've done this before too, where the kid's school has all these different packages that you can go bid on it. Then if you're the winning bid, then you get the prize via an auction. That can all be done electronically now. Again, that does not impact type 2 gaming. There was a type 2 gaming change allowing electronic participation, but it did not survive the legislative process. Technical updates. We made some clarifications to the code, one of which clarifying that special disqualifications do apply to liquor retailers. That wasn't clear in the code previously. We were still enforcing it that way, but it wasn't clear. So we've made that clarification in the code. We also updated the scope of the wine retail permits, clarified some items there. We made a clarification that this is a really esoteric provision of the code. I think anyways, it wasn't something that I was super familiar with. Don't look at this as a substantive change. It sounds like one, but it's really not. It bans sales to non-permittees and it applies to all permittees. That doesn't actually mean you can't sell to anybody else. The code says you can't sell to another permittee except for customers and employees. So it doesn't actually change anything. We just made it a cleanup. Instead of referencing permits specifically and naming them out, we just said all permit holders. We clarified that the ban on purchasing alcohol purchasing multiple alcoholic beverages for one price, that does not make unlawful event packages. So we clarified the code to say that, hey, you can go and buy $2,000 for a package of alcohol where somebody's going to come be the caterer of alcohol at your son or daughter's wedding. You can now clarify in the code that you can buy event packages from permit holders. Finally, we created consistency across all the IC references to the term tobacco product. And on the next slide, I have that definition spelled out. So tobacco product now means a product that contains tobacco or nicotine, including an e-liquid as defined by blah, that contains nicotine should be struck out. When I copied and pasted this, I apologize. It did not strike that out. So the term that contains nicotine should be struck. We will update that for when we post this. I apologize. It did not catch that did not paste properly. But it is including an e-liquid, whether or not it contains nicotine. And it's intended for human consumption, is not approved by the FDA for tobacco cessation. So this definition is now used throughout Indiana code. All references tobacco product now reference that definition. So that should make things cleaner for our excise officers and for all of our tobacco certificate holders out there. Additionally, on tobacco side, we updated the code to allow a alternative infraction charge for minors using fake IDs to buy tobacco. Current law, we only have a misdemeanor. So for whatever reason, the code provided that if a individual minor uses a fake ID to attempt to purchase tobacco, we have to charge them with a misdemeanor. It's the only charge available. For alcohol, it could be an infraction or a misdemeanor. So we updated the law to make it clear that excise can charge minors using a fake ID to buy tobacco with an infraction. Okay. Type 2 gaming definition, we updated to be consistent with the memo that the Gaming Commission issued that was referenced in the code previously. This isn't a substantive change other than the maximum ticket price being referenced at $10 in the code. So essentially what this does is creates a new category of type 2 gambling game that's sports wagering themed. And in the maximum ticket price for a sports wagering themed type 2 gambling game is $10. So again, not a substantive change, just taking the reference to memo out and then putting in the definition that was in the memo into the Indiana code. Charity auctions and raffles, I wanted to expand on that a little bit. Again, it allows electronic participation in the charity raffle or auction, but not type 2 gaming. And it still requires that the individual, if you are auctioning off an alcoholic beverage, if you're the winner, you have to be in person, prove your age in order to pick up the beverage, the alcohol. So this is not applying to type 2 gaming. I really want to be clear on that. If you have a gaming endorsement and you have type 2 gaming operations at your establishment, you can't do online. That's not allowed. Donations. This was a big one, and I think a very important piece of legislation, because we were really running an informal sort of donation vetting process at the ATC prior to this code change. What we did is now every single scope of permit for alcoholic beverage permits now includes the authority to donate product. So previously that was not expressly provided in all of the code sections and all of the scopes of permits. Now it is. We also created a new chapter, which is 7.13.6.3. You may or may not be aware there is 7.13, 6.1, and 6.2. Those are charity auctions and charity raffles. We added a third category of a charitable event, that is a charitable event at which donated alcoholic product is consumed on premises. So let's say that you donate product to a charitable golf outing or dinner or whatever it might be, and that alcohol that you donated is being consumed by participants of the event on premises at the event. That is now expressly authorized. As a permit holder, you are no longer limited to donating to alcohol just to auctions and raffles. You can now also donate to these events for on-premises consumption of the alcoholic beverages. What 6.3 also does, beyond just creating that legality and that new charitable event type, it also sets the stipulations and restrictions on donations between permit holders. So all of the substantive requirements, rules, stipulations, conditions that are in 6.3 only apply if a permit holder is donating product to another permit holder that's a qualified organization. So otherwise, if you're a permit holder and you're donating to United Way, some charitable organization that's not a permit holder, those rules and stipulations don't apply to you. Okay. So I want to make that really clear. That chapter, other than the first couple of provisions that lay out this new event type, the limitations imposed are on donations between permit holders only. We also clarify in there that you cannot donate cash. Permit holder donation of cash is illegal under federal law. It's not ethical. It has serious issues. So that's obviously banned under the law. You can donate cash, of course, to a qualified organization that is not a permit holder. There's no problem with that. That's actually encouraged and a good thing. And that's really, I think, thematically the reason we wanted to make it expressly clear that donations are lawful and here's the restrictions on permit holder to permit holder, was because this is a good thing. These are permit holders that are acting charitable, that are helping foster community services and community events, that they bring positive change, and there's generally a good thing, right? So we want to make sure that we don't unnecessarily hinder those charitable activities while also creating clear boundaries in terms of permit holder to permit holder transfers without consideration, without payment. So yeah, okay, we can go on to the next slide. If you have questions about the donation stuff, just drop it in the chat. Liquor liability insurance, we updated this. This is another one where we saw struggles in the industry and with our permit holders, especially smaller permit holders, non-commercial permit holders like a fraternal organization, where either they couldn't get insurance at all it was cost prohibitive because they have very low sales of alcohol, or the insurance providers in their area would only provide up to like $100,000 in coverage. Previously, or currently the law says $500,000 minimum in coverage. That was too high. We realized that. We learned the lesson from last session to now, that just didn't work. I worked with Representative Lehman on this, and he is an insurance industry member, so he understands this stuff very well. We sat down, talked about the issues permit holders were having, the reasons why it was happening, and how we could rectify the situation. So what we did is we clarified the exemption for craft manufacturers who don't have on-site consumption. So we added that if you're a craft manufacturer, you only have to have liquor liability insurance under the law if you have a tasting room where there's on-site consumption, or you have a retail permit. Those two situations you would need to have liability insurance. But if you're a craft manufacturer without any on-site consumption, you don't need liquor liability insurance. We also removed the minimum coverage requirement. So like I said before, you had to have $500,000 in coverage. That has been removed. So there's no longer a minimum. Our hope is that that will just result in insurers and permit holders coming to market risk-based decisions to obtain the amount of coverage they need as a company, what makes sense for them. We don't want to see, obviously, I don't think this would happen. I don't even know if it's possible, but I want to see like $5 in insurance coverage. If we start seeing that type of thing, or $1,000 in coverage, something that's just ridiculous, that serves no value, we may have to look again at adding the cap back in at some lower value. But for now, we've removed the cap altogether. I hope that's not an issue. And I hope, again, that reasonable market risk-based decisions are made regarding coverage amounts. We clarified that coverage under the law can be an endorsement to a general liability policy. It doesn't have to be a standalone policy. And then I think this is an important one for, again, our non-commercial permit holders. We create an exception. If you're a permit holder that has $25,000 or less gross annual receipts from the sale of alcohol, you don't have to have insurance under the law. So we will build in a question tree in the applications where you can ask for that exception, and then you have to produce some evidence that you didn't have an excessive amount of sales for alcohol in the prior year. Secondly, on this slide, we have ownership disclosure requirement modernization. This is another one I think was overdue a little bit, or at least due to happen. Currently, Indiana law actually, this is in effect now. This is one of those emergency effective date provisions. So this is effective today. You previously had to disclose every owner with 2% or more interest, passive, active, didn't matter. Just an interest in the permit had to be disclosed if it was 2% or more. We changed that to 5%. And then we limited that disclosure requirement to owners with an operational control aspect of their ownership. So I don't want to go into a bunch of examples, because I really want to see the applications coming in and sort of grow that set of examples, instead of saying, well, if you're the president of the company, you have to be disclosed, but if you're just a trust beneficiary, you don't have to be disclosed. That's the type of thing that we could assume, but it's not necessarily the case, because there could be a trust instrument that gives a beneficiary control over the operations of the permit that's owned by the trust. So I don't want to make any blanket statements, but I will tell you that the disclosure requirement now is limited to individuals with an active interest in the permit, where they have operational managerial control over the operation of the business, the permitted business. An example where that definitely would not require disclosure: a shareholder in a publicly traded, that's already not required, but a shareholder that's an employee-based stock program, or a pension fund holder that has an interest via private equity. So we're seeing a lot of security funds and private equity funds that are purchasing interests in these permits, or purchasing the businesses that own these permits. And then we're seeing those funds are in turn invested in by pension holders from various places. I believe the craziest one, or strangest one I saw, most surprising anyway, was the Icelandic public employee pension fund. There's also a permit that there's the interest from the Panama Canal Credit Union has an interest in the permit. So those types of shareholders that are way down the list and they have a very passive interest, they don't have to be disclosed anymore. So I won't belabor that any further. We can move on to the next slide. These are two changes that really were driven by the ATC, and these are public safety, public health related changes. First off, we banned the sale of flavored nitrous oxide by permit holders, except for, tobacco distributors can't sell flavored nitrous oxide. They're not restaurant suppliers, right? So what the law says is that if you are a restaurant supplier, either wholesale or retail restaurant supplier, and you're selling flavored nitrous oxide to an individual for a culinary purpose, you can sell it. If you don't meet that condition, you can't sell flavored nitrous oxide. So ipso facto, if you're a tobacco certificate holder, you're probably not a restaurant supplier, so you can't sell flavored nitrous oxide. We added that to 7.1 to make it an express violation that is pursuable by ISUP and then can be referred to ATC for action. And it's also a misdemeanor. So if you are not a restaurant, retail, wholesale supply company and you sell flavored nitrous oxide, then you have committed a misdemeanor. So flavored nitrous oxide, also known as whippets, I think most people who are in the industry know what it is. It's extremely dangerous. It's a toxic substance. It kills people. It maims people. It makes them brain dead. So stop selling it. Nicotine analog. This is one that's less obvious in terms of we see the damage to Hoosiers already, but it's one that we're trying to get ahead of. So a nicotine analog, this is sort of an emerging product where it's not actually nicotine. So it doesn't have to follow all of the tobacco nicotine regulations, but it is marketed as, and it has chemical lookalike structure. It's marketed as and looks like nicotine. So it's like product A, and I'm selling it. I say, hey, this is just like smoking a cigarette or snooze or whatever. It gives you the nicotine buzz, but it's not nicotine. That's now illegal under Indiana law to be sold. So as we see examples of these nicotine lookalike, nicotine analog products, I will supplement and I can provide that information as I meet with you all as industry groups. But as a general matter, if a wholesaler comes to you, if a manufacturer, distributor, whatever comes to you with a product and says, hey, I've got this product and it acts just like nicotine, the chemical structure, the chemicals act just like the nicotine chemical, don't buy it because it's illegal. And we have also given the ATC the authority to recover disposal costs for contraband. So if a bunch of flavored nitrous oxide is confiscated by excise police, ATC can recover the costs of disposing of that contraband via civil penalties or through the action, the prosecution by our prosecutor. And that would include contraband is defined essentially as any substance that is sold in violation of the criminal statutes. So all of that stuff you could be liable for paying for our disposal costs. Few more here on the HEA 1275. The Civic Center permits. Every single civic center permit that can be held by a local government entity, we updated so that the local government or the concessionaire could obtain the permit. So if you are a local government and you have a municipality and you have a permit for a park and you have a vendor that operates in there, the vendor could apply for and obtain the permit. So anywhere in section 25 and 7.13125, every single one of those provisions, it says that the concessionaire or the vendor with the entity with a contract or agreement with the local government to operate as the alcoholic beverage vendor, they can now obtain the permit. Idea being reduce liability on the local governments and give the opportunity for business actors who are accustomed to permitting process, let them be the ones who obtain the permit and manage it. We have a new employee permit requirement essentially for bouncers. So individual employees of a permit holder, retail permit holder, you're responsible for controlling entry into an age-restricted location and for checking the IDs to determine age. If you're responsible for both of those things, then you have to obtain an employee permit under the law. Can answer questions on that for clarity if you need it, but it's essentially like the bouncer-like role. What this doesn't apply to is like the hostess at the restaurant that's just seating people. doesn't apply to them. Now, if for whatever reason you have your hostess checking IDs and controlling entry and then allowing people in based on their age, yeah, that applies to them. But that's probably not going to happen very often. The Doyle Fund, this is super inside baseball stuff, not going to impact the industry, but we have a Doyle Fund, and the Doyle Fund currently, that's where all the tobacco related monies go from civil penalties imposed in relation to tobacco violations. And currently that money can only be used for youth tobacco enforcement and educational activities. We open that up to all tobacco related enforcement educational opportunities. Idea being we can use more of that dedicated fund on an annual basis and maybe relieve some pressure on other areas of the budget so we can pay for other aspects of operations with our legal fund, our general administrative enforcement fund. Last thing on this one, small breweries, we added the small brewer and the connected retail permit to the exemptions to limited separation that are provided by 7.15 711. That is the, I don't know, 40th exemption now for limited separation. So small brewers and connected retail permits, you're now exempt from limited separation.
Chris, I'm going to go ahead and interrupt you here for our first code word. I have a theme for these to celebrate the Pacers making the NBA Finals. So the first code word is going to be underdog. Underdog. And I will drop that in the chat. Thanks, Chris.
Thank you. Good time. I needed some coffee. All right, next slide. All right, on to HEA 1276. This bill was, yes, sirs, I agree with that chat. That one caught my attention. 1276, this was Representative Manning's public policy bill, ended up being an alcohol tobacco bill. And I think it makes some positive changes to the code. So I'll go through each of these in detail on the relevant slide. First one, farm market participation. I know that some segments of the industry are very excited about this. This was another change that was perhaps overdue. Essentially, what we did is, what the legislature did is open up farm market participation to all craft manufacturers. So previously, only farm wineries could participate in a farmer's market under Indiana code. In their scope of permit, it was expressly allowed. We have now expanded that to all craft manufacturers, only limitation being that while craft brewers and farm wineries can offer samples and sell for offsite consumption, artisan distillers can only sell for offsite consumption. Artisan distillers cannot offer samples. We've also given some local control over this. A local government entity can adopt an ordinance that limits the farm market participation of any one or all of the craft manufacturers. So the local government could say, or the municipality could say, farm wineries can give samples and sell off-site. Craft brewers can sell off-site. They can't give samples. Artisan distillers can't participate. Whatever they want to do, they can do that. And then it's on the individual permit holder to make sure that we know of that ordinance when they file the notice of the event taking place. You will find a request to participate in a farm market in the MO1 application here shortly. We're working on that implementation. It should be ready by July 1. Expo days were increased from 45 to 75 to accommodate this new allowance of farm market participation. So now if you're a craft manufacturer, instead of having 45 expo day per year, you now have 75 expo days per year. And this request will also be found in MO1 shortly. Next slide. Okay, dealer transaction limits. So under current law, every single scope of permit for a dealer, actually except for liquor, I think, actually provides a per transaction limit on the volume of alcohol that can be sold in one transaction. So what was happening was you go to the package store and you go to the you buy enough to meet the transaction limit, but you have more to buy. You just get rung up twice. That's what was happening. We get it. We repealed the limitations on the transactions because it wasn't serving any value. In terms of the liquor retailers and dealers, you can now serve samples of mixed beverages. Ready for the next slide, please? We created a new three-way theater permit. This is for a city that has a population of between 18 and 20,000. You think there are lots of those. There's one, it's Logansport. It has to be an indoor theater, and it's a historic district. The theater is located in a historic district. It's a Logansport downtown theater. That's that theater permit. We created a update to the food hall master permit. That again, is for hundreds of locations called the Indianapolis City Market. And the patios. So we are now allowing patios. Well, the legislature is allowing, and Indiana code is accommodating, and we are enforcing the allowance that a retail permit holder, you can now have a patio that isn't directly connected to your building, like with a door to the bar area, et cetera, as it currently is. Now the patio can be located within 100 feet of the permitted building. Couple of important stipulations on this, and I really hope this doesn't get unwieldy in terms of trying to enforce. Your patio, there cannot be any third-party property interests between you and the patio. So you got permitted establishment here, and then you got Jim's house here. You can't have your patio over here. So there can't be anybody else. Your neighbors can't have a piece of their property between you and your patio. Has to be contiguous, connected, adjacent to the permanent building. Okay. One exception to that, it can be located in a right of way, but you have to have the written permission of the right of way owner, whether that be NDOT or the state agency or the local government. And I hope there's local government encroachment forms that you can get a right of encroachment on a right of way. Most local governments have a form for that. So hopefully you'll be able to locate that form and work with it. Otherwise, we can figure out what that written consent looks like on an individual basis. Anything that's signed by the right-of-way owner probably is adequate. If you have a patio that's non-contiguous that meets these conditions, contact your local board officer, and you can work with the local board officer to get that permanent floor plan amendment completed. They will be able to help you get through that process. So that's that. I could talk about that a lot longer, but we'll get out some guidance for you in terms of what the policy constraints are to this non-contiguous 100 feet of the permitted building patios. But I do think it's a good thing. There's a lot of locations that have patios that don't meet the very specific requirements of the current law that are fine. So we'll make this work as a collaborative industry. So we can go to the next slide, please. HEA 1468. This is my last bill before calling it to talk. So 2 changes to do with cigars. So cigars, buying fine cigars, cheap cigars, whatever, it's becoming more and more popular, especially I think on the high end side of that. And as a result, there was some industry desire for some allowances for commercial arrangements involving cigars. So the first is a cigar room. So you're a restaurant, club, hotel, permit holder. You can have a room that is not connected to your dining room, that is segregated, and it's a closed room. It's ventilated with a contained or otherwise well-ventilated system, and it's there for cigar consumption specifically, not tobacco consumption generally, just cigar consumption. It has to be connected to an outdoor patio, and it has to have signage on all of the doors saying you have to be 21 or older to enter. In terms of smoking bans, you either have to be located in a jurisdiction that allows for a cigar room type scenario, or you need to obtain the written permission of your local government, either via ordinance change or just written permission of them saying, yes, you can have this cigar room. We can talk about individual cases as they arise. There is no special permission you need to ask for from us other than just a floor plan change if this is a new component of your floor plan. Emergency was created for this provision, so it is effective today. Last thing here is the supplemental cigar sales certificate. So this looks a lot like supplemental catering, except for tobacco certificate holders. And what this allows is a tobacco sales certificate holder can obtain a supplemental cigar sales certificate to sell cigars at an event located somewhere other than their licensed premises. So you gotta have a tobacco sales certificate, and this has no effect on the state smoking ban. you can just sell the cigars at the event. It doesn't open it up to smoking the cigars. That would be subject to state and local smoking restrictions, and it would be obviously on a case-by-case basis whether or not smoking would be allowed on the premises. But if you are a cigar enthusiast and you also have a tobacco sales certificate and you'd like to start participating in events and catering and selling cigars at these events, then this may be the permit for you. The administrative terms, it's a $1,000 application and renewal fee. It's a 3-year permit, just like the tobacco sales certificate. If you've got the new cigar permit, you got to give us 5 days notice before any participation in an event. 5 days before the event. Doesn't say business days. It's just 5 days before the event occurs. That'll be online only through My License One. And again, this is a separate and distinct license, subject to separate and distinct suspension, revocation, etc. So that is that. And I think the next slide will be handing over to Colin. All right, Colin, I'll kick it to you.
All right, thank you so much. I appreciate the opportunity to be here today. My name is Colin Davis. I'm the Director of Tax Policy, as Chris mentioned. We are proud to be a collaborative partner with both the ATC and the stakeholders that are present today. If you have any tax matters that you want to discuss with us pre-session or during session, hopefully pre-session though, feel free to reach out to me and we'd be glad to discuss those with you. But today we'll focus on some of the bills that had an impact on stakeholders. Not everything that obviously the DOR was interested in, otherwise we'd be here until 5 p.m. Some of the stuff Chris already covered, but I'm just going to give DOR's summary of it, which shouldn't conflict at all, but just so you have it there today. So we're going to touch upon the budget bill, HEA 1001, which had some tax rate changes and some funding changes for cigarette, OTP, closed system cartridge, and electronic cigarette taxes. The Department of Revenue's agency bill, which is SCA 453, that included some technical changes for some OTP, closed system cartridge, and e-cig matters. And then HEL 1275, which Chris obviously covered as well. And then just some ongoing issues that we thought it would make sense to discuss. They really have nothing to do with legislation from this year, but this seems like a good opportunity to talk about it. So we can start with the budget bill. As most of you know, effective July 1st, 2025, the tax rates for cigarette tax, OTP, other tobacco products tax, closed system cartridge tax, and electronic cigarette tax are increased. The distribution of these taxes, plus the associated penalties, fines, and fees that go with the taxes, change as well, so that most of the funding from these taxes will go towards Medicaid and other medical-related funding as part of a larger initiative to shore up Medicaid costs. So the first thing I'll talk about is the cigarette tax increase. The cigarette tax rate went up from 99 cents a pack to $2.99 a pack. This is for Class A cigarettes. Class B cigarettes went up to $3.98. The funding mechanism for the tax fees, fines, and penalties collected under the cigarette tax chapter changed as well. I highlighted how the Medicaid current obligations went up from 2.46% of the that amount collected to 59.38%. So that really demonstrates how the funding mechanisms changed towards Medicaid costs. Next slide. The component of the legislation is that there will be an inventory tax for revenue stamps that are in the possession of a distributor prior to the July 1st change. So distributors that have in their possession these revenue stamps can continue to use them only if the full amount of the new cigarette tax rate is remitted to the Department of Revenue under procedures that we will prescribe. So the statutory language here is nearly identical to the language that was put in place back in the last time that the cigarette tax rate was changed in 2007. So we're going to use similar procedures, but luckily this time we have a brand new or relatively new tax management system. So we haven't. I don't believe that we've issued the procedures just yet, but there will be a release soon to describe how the difference in tax rates will have to be remitted to the department. The physical inventory for purposes of this inventory tax means all Indiana stamped cigarettes in the possession of the distributor, whether it's located in a warehouse, on the docks, in their trucks, or any other place where the distributor has a risk of loss, and also those unaffixed stamps, including any stamps that are in transit from the department to the distributor. That by close of business on June 30th, 2025. So it's not just unstamped, unaffixed stamps that are subject to this inventory tax. It's all the stamped cigarettes as well, that where there's a risk of loss. And again, we will hopefully get I think the instructions were supposed to be posted by June 2nd. I haven't checked to see that if that's the case. So I can check and let Ashley and Chris know so that they can inform you if that's been posted yet. One important note is we've gotten a lot of questions from retailers asking if they are also subject to this, and they are not. The distributors are the ones who are subject to the inventory tax and must account for the difference in the tax rates. Retailers have in their possession stamps which demonstrate that the tax has already been paid. Retailers don't have a tax obligation for cigarette tax, so that's not on them. Similarly, other tobacco products tax rates went up from 24 to 30% on tobacco products other than moist snuff. That has been increased from 40 cents to 50 cents per ounce. The tax rate went from 24 to 30% on whole price of cigars. A couple years ago, there was a maximum tax amount that was imposed on for cigars that they couldn't exceed $1 in taxes. That's been increased to $3. And the tax rate on alternative nicotine products like lozenges and such went up from 40 cents to 50 cents per ounce. And again, the close system cartridge tax increased from 15 to 30%. So close system cartridge tax and OTP tax are in the same chapter. So the increases, the changes in funding for both tax types is in the second bullet point here. So you can see how the funding changed as well. But mostly there's just that slight change to the Affordable Housing Community Development Fund, and then the remainder will go in the same schema as the cigarette tax. And then finally, the electronic cigarette tax also went up from 15 to 30%. And then the funding changed as well with a greater amount going to Medicaid. So next we'll talk about the Department of Revenue's agency bill, Senate Bill 453. We increased the renewal rate from annually to every 2 years for other tobacco products distributors license, closed system cartridge tax distributors license, and e-cig tax retailer dealer certificate. We felt that it was a burden on both the license holders and the department to require to send out notices to people every year to renew their license, and then for those license holders to to fill out the information and send in the money to have those renewed and for us to then process it. So we went with every 2 years because that lines up with other licenses with the department and that the department issues, and we just feel like it's more equitable that way and saves money and time for everybody. We also made technical changes clarifying who's responsible for collecting OTP tax or closed system cartridge tax in distributor to distributor transactions. The language is already there for OTP tax. It should have also been copied to the closed system cartridge tax. It was just an oversight that it hadn't been included. The closed system cartridge tax language pretty much is identical to the language for OTP tax. It's just a half section away. Next slide. And then finally, as far as legislative changes, back to HEA 1275, again, the closed system cartridge tax or OTP tax distributors are prohibited from selling that or using or distributing that flavored nitrous oxide, which Chris mentioned. And then we have the ability to suspend or revoke a distributor's license and impose sanctions on those distributors an equal amount to the cost of disposing the flavored nitrous oxide if a distributor violates those requirements. So again, that's something that we're seeing a lot. ATC is seeing a lot more of, and it's certainly something that needs to be addressed. In this final slide, I just wanted to address some ongoing issues that have been presented to us. We went through a kind of initiative where we performed a review of retailers and distributors who were selling electronic cigarettes and closed system cartridges to find out who needs to be registered. And something that came up quite often is that some people said, well, the products that we sell don't contain or can't be used with nicotine, so they're not subject to the closed system cartridge tax or electronic cigarette tax. That doesn't matter. The relevant definitions make no mention of nicotine as being a requirement for these products. They could be used with nicotine, CBD, or any other substance, or no substance at all. It could just be a flavored electronic cigarette with no nicotine or CBD or anything, and it would still be subject to the electronic cigarette tax or the closed system cartridge tax, depending on the type of product, as long as it met those definitions. The Indiana General Assembly purposely did not include a mention of nicotine because they wanted to cover all these different types of products, regardless of whether it contained nicotine or CBD or anything else. Similarly, the definition of alternative nicotine product makes no distinction regarding where the nicotine is derived. So we've had some people say like, well, this is not naturally derived nicotine from tobacco. That doesn't matter. If it's naturally or artificially derived from tobacco or another plant or what have you, it still meets the definition of alternative nicotine product because there's no mention of where the nicotine is derived from where it's derived. And we've also heard there's industry confusion still between open and closed products at retail. If you look at General Tax Information Bulletin, I want to say 206, we have a chart that lists out what types of products are subject to either tax. And we are more than willing to update it if there is continued confusion. But I would encourage anybody who has confusion to look at that table and just see which products are subject to which tax. And if you have any questions about that, feel free to reach out. And then the proper licensing for electronic cigarette tax. There was clarification a couple of years ago that about the retailers and the type of there's confusion, I guess, because you have the closed system cartridge tax, but the other tax is called the electronic cigarette tax, and it used to be called the electronic cigarette tax retailer's license. That's been changed to the open system retailer's license. So there's still confusion about closed system versus open system and who's subject to what. So I think that clarified it, but if there's still confusion about that, please, again, feel free to reach out. And I think our next slide might talk about who you can reach out to for ongoing issues. Yeah, so I'll let ATC cover their context, but you can contact tax policy at dor.in.gov, and that will get to one of our attorneys on the tax policy team, or you can call the special tax section directly at that number there. You can also reach out to me directly. I've been very involved in all of these electronic cigarette tax matters and alcohol tax matters over the years. So my email is there as well. So I'll turn it back over to Chris and Ashley to cover anything else. But thank you again for allowing me to participate today.
Thanks, Colin. That was great. I think we're ready for our second code word, which I will drop in the chat, but that code word is victory. I'm speaking it into existence right now that the Pacers will have a victory tonight. So, and then I think now that we've done our second code word and we've covered all the slides, I think we're going to open it up to questions so we can hopefully answer those.
Okay, Ashley and Chris, we've received several questions during your presentation, so I will go ahead and get us started. The first two are just about the presentation itself. I'll just combine those. So number one, will you be sharing this PowerPoint with everyone on the call? And
Yes.
where can you find the CLE attendance form?
The PowerPoint will be shared, and I'm going to update it though to strike the word contains nicotine so that we aren't confused about the tobacco definition. Ashley, where's the CLE? Is that on our website, the registration form?
Yes, it should be on our website. If you go to
Good.
legal and policy resources and then webinars and trainings, it will be listed there.
Okay. Next is a question from Danielle Campbell-Weiss. And she has a question regarding the new liquor liability insurance requirement changes.
Mhm.
So for the exception for permit holders with gross receipts from sale of alcoholic beverages of no more than $25,000 in the prior year, can a new applicant still ask for the exception?
Yes, they can. There will be an opportunity to make a certification that you don't anticipate first year sales exceeding 25K. And then obviously in your subsequent renewals, you'll have to provide the actual gross receipts. So yes, a new applicant can ask for the exception.
All right, our next question is from Christopher Nussbaum, and he has a question regarding the new chapter 6.3, section 4.
Right.
So I'll just read this for everybody. A qualified organization may serve alcoholic beverages for consumption on the premises during an event that are 1, purchased by or donated to the qualified organization by a permittee or a person that is not a permittee, and in sealed bottles or cases. And his question is, does this mean that a qualified organization would not need a caterer any longer if all alcoholic beverages are donated?
Well, you'd have to have employee licenses with the individuals who are serving the alcohol. Ashley, I don't know if you want to jump in on that at all to supplement.
Well, I was just gonna say, regardless of the event, I mean, there still has to be some underlying authority in order to serve the alcoholic
Well,
beverages, right?
Yeah,
So,
temporary permit or good point.
right, you could still utilize a supplemental caterer to serve those donated products if you don't have any employees that have their own server permit.
So in other words, no, it would not, it really doesn't relax any of the underlying expectations or requirements regarding catering authority or having a permit. So you still need a permit to operate. You just may receive more donated products than purchased.
All right, this one comes from Christopher Oliver. When do retailers need to stop selling nicotine analog products if currently carried?
July 1 is the effective date. So last day of June.
Then we've got one from Kara Burgess. Do you know whether the disposal of nicotine analog products will follow disposal practices of ENDS products, ENDS products?
There's no sell-off after the effective date. So Jessica, I think you answered this question in the chat, but there's no sell-off post-effective date. So you just need to have all your stuff disposed by July 1.
Okay, and then we have one from Aaron O'Rourke. If a nonprofit organization is also a permit holder, alcohol partners interested in sponsoring events with said nonprofit can only donate product, not cash, correct?
That's correct. There is a process by which you can ask to make a cash donation to our support services, but I don't see any circumstances where it would be allowed because federal law prohibits cash donations between permit holders. So that's one where we don't have a lot of leeway to give an exception. So just need donated products only.
And if there are any future sponsorship requests, make sure you submit those to Lieutenant Brian Stewart with the Indiana
Yes.
State Excise Police.
Thank you. And we'll look at those on a case by case basis. So definitely make the request and we'll take a look at it.
All right, then we've got three from Clark Kirkman. I'll take those one by one. Number one is, are bars allowed in the cigar room?
If they have a hotel, club, or restaurant permit, those are the three permit types that are allowed to have a cigar room. Are you saying can you have a bar? Oh, can you have a bar in the cigar room? I see. I didn't understand that. I'm going to say no, just based on what the clear language of the statute is. I would need to look at that a little bit more. There's probably also some smoking restriction limitations that would be imposed on that. Jessica, you have thoughts?
I don't think there's any prohibition on the bar in the room, and it's 21 and over. So I would say,
Right.
yes, a bar could
Okay.
be in the room.
Okay, so it'd just be subject to the smoking prohibition, I guess. But good input, Chair. Thank you. So that one's a yes, Clark.
All right, second one, how does the change regarding legal status affect entities with internationals on their ownership?
It doesn't. The terms are the same. So the legal term of art is the only change there from alien to legal status, but the definition is the same. So no impact. Nothing's going to change in terms of our enforcement. Clark, you know that the applications currently say citizen as it is, which is not even an accurate reflection of the law. So don't worry about that. No change.
And then should we expect administrative rules regarding donations or any other new legislation?
Sure. I maybe eventually on the donations and just generally, we obviously want to have lessons learned before we go in and make rules. So if we see some of the contours of like the logistics, how donations are happening, where we're seeing common issues, we may make some administrative code, new administrative code, but we aren't right now in the foreseeable future. We don't plan on making a bunch of new rules.
Okay, next is from Kara Burgess and Colin. I think this one is for you.
All
This is a clarifying question for DOR. Is the requirement for renewal of a distributor's cigarette license still annual, or has that been changed to every 2 years as well?
No, we did not change the cigarette tax license. It was only OTP, closed system, and electronic cigarette.
All right.
Great question.
Chris, did you have a follow-up?
No, I was gonna say it's a good question. Good question. They're all good
All right.
questions.
We got one from Nicole. For the renewal rate on licenses being changed to every 2 years instead of every year, does this affect current licenses that have an expiration date listed on the license that is 1 year from the date this license was issued?
You know, I've been in some of the discussions on that, and I'm not quite sure I have a good answer for it just yet. I would say stay tuned. I think after a certain date, some people will have to. I forget when it becomes effective. I think July 1st. So I think it will become. Let me look into that and get back with an answer on that, if that's okay.
Okay, and we just got a question in the chat from
Yeah.
Adam. Can you link to the Bulletin 206 mentioned by Colin that defines and gives examples of the different vape products?
Yeah, let me just copy and paste that now. I'll put it in the chat.
Sweet. Thank you.
Yeah.
We could probably put the the CLE registration in the chat too. I don't know if we're ready to do that or not, though. Ashley.
I should have already dropped a link
Okay,
to our
I thought it.
website, but let me
Perfect.
know if it's not working.
Okay, thank you, Ashley.
All right, and then we have a question from Tim Eaton. As a small brewer, when catering an event with the proper permitting and the venue wants to serve non-craft beer, what limitations are where the mass market beer can be purchased?
Okay, I'm gonna read that and then I'll answer it.
Yeah, that's, it's in the question, eh?
Yeah, I see it. I see it. Thank you. Where the mass market beer can be purchased. Ashley, do you want to answer this question? It's not really a ledge question. You may have more to say about it, but I mean, I would say generally the sourcing limitations you buy from a wholesaler, a distributor, a dealer. If you're operating under a temporary permit, Ashley, do you want to expand on that?
What was the question?
As a small, okay, so this is a small brewer that's asking the question, but they're catering the event. They want to know where the venue can buy non-craft beer from, and it's a wholesaler, distributor, or dealer, right?
Correct.
It would depend on the permit type that's
Yeah,
being
'cause
used for the
they're-
authority.
Exactly.
So
'cause-
a supplemental caterer can only purchase the other beer from someone authorized to sell it wholesale. So a wholesaler, potentially a craft manufacturer, under certain circumstances, a temporary permit holder can purchase from anyone authorized to sell in Indiana. So under a temporary permit, it could be purchased at a packaged liquor store, a grocery store, for the temporary permit.
Great, thank you. Yeah, so it just depends on the permit type.
Are you ready to move on to the next question?
Yep.
Okay, this one's from Kara Burgess. For nicotine analog disposal, more specifically, is it considered hazardous waste like nicotine e-liquid is? I'm thinking of guidance for schools and parents for disposal of these products if there's an influx of sales, like when Juul flavors were banned and users stocked up big time.
I honestly, I do not know the answer to that question in terms of the categorization of nicotine analog products. To my knowledge, I am guessing that they don't qualify the same as nicotine e-liquid because nicotine is probably categorized specifically as a hazardous material, whereas non-nicotine analog is more of a generic term and it could refer to various chemical structures that may or may not be hazardous. You know what I'm saying? So I think it probably depends on the non-nicotine analog product, specifically what the chemical structure of that product is, whether or not it generally fits that definition. So I would say generally, no, nicotine analog is not a hazardous material as a category. However, there may be individual products that fit within that category that are. So that's maybe a cop-out answer, but it's such a generic term that I can't really say if a specific product would or wouldn't be hazardous.
All right, we have a follow-up question from Christopher Nussbaum regarding the catering. So he says, so normally a caterer wouldn't be able to accept product or serve product not from a wholesaler. So would the caterer be able to serve the donated product to the qualified organization?
I need to read that too. Go ahead, Ashley.
That's in the chat, not the
Yes.
Q&A.
I believe so. You just want to be sure that the donated alcohol product is completely separate and segregated from any other alcohol used by the caterer or any other permittee.
Okay, so the caterer is serving on behalf of the qualified organization. So yeah.
But can they avoid I think the question is, can a brewery or a craft manufacturer who's donating circumvent the wholesaler to deliver the product
If it's
to the
donated.
catering location? And I thought they had to have a zeroed out invoice.
Correct. Yeah, no, they can't bypass the wholesale system. If it's a product that has to go through a wholesaler, it should go through a wholesaler. And when that donated product is provided, there should be a zeroed out invoice.
And Chris, we can chat. If you have a specific fact pattern, shoot me an email, the whole group an email, and we can help you with more specificity. If we need to like have a back and forth, we can sit down or have a quick call or whatever. So just shoot us an email, Chris.
All right, next we have one from Alyssa. Do we need an alcohol buyer's license to purchase from wholesale distributors?
This one I'm a little confused by. Are we talking about like, are you a supplier? Are you a manufacturer? Or are you just obtaining a temporary beer and wine permit? I think we need a little bit more context for that question.
And then she also asked, how do we pay alcohol sales tax? So Alyssa, if you want to give some more information, oh, let's see, mobile beer and wine trailer. Does that help, Ashley?
Yes. I mean, you would need to obtain a temporary permit prior to obtaining the alcohol from a wholesale distributor. So that would be your authority to purchase the alcohol. Does that make sense? And I'm not even going to attempt to answer the tax question because that's not in my wheelhouse, and I can't give you legal advice on how to run your business.
Okay, with that,
Colin,
Colin,
do
I
you
was gonna
have,
say, Colin, do you want to jump in?
How do you pay sales tax on alcohol? That's the question? Unlike from a beer and wine trailer?
Yes,
think
I
it's
believe
this-
so.
I think is it the excise tax? Is that what she's asking about? Or
Is it excise tax or sales tax? Because sales
It must-
tax is just normal. You just collect it when you sell it.
excise tax?
I wouldn't. Then they jumped into a sales tax. I mean, I'm not really sure. The excise tax should have been paid prior to the retail sale.
Yeah.
So on the sales tax side, I mean, you should be registered as a retail merchant before you make any retail sales, and then you would collect 7% on any. Plus, if you're in a county with a food and beverage tax, you should be collecting sales tax and the appropriate food and beverage tax on. You should have a point of sale system or something to help you
Mhm.
keep track of. But again, I can't. That's beyond what we can say. You just need to be registered with us and collect the 7% sales tax. Anything else is something you should talk to a tax professional on setting up your business and how you should be collecting it.
Yeah, but it's all point of sale to answer the
Yeah.
question generally, and then just work with a tax professional as you set your business up. It's always a good idea. So thank you, Colin.
All right, we're going to move
Yep.
on to a question from Julie Whitson. As a point of clarification, since limited separation is no longer required for smaller brewers, is it safe to say that a small brewery that currently has separation installed could remove that?
Yes.
All right, and next we've got one from Derek Marshall. I think this may be the same question. Do we need an alcohol buyer's license to purchase from wholesale distributors for a catered event? So I think
You have
that
to
may
have
be
a permit.
related.
Yeah, you have to have a permit of some kind to have the authority to purchase from the wholesaler. So, yeah.
Okay,
We're right about at 11:30. I think did we get all the questions?
I think we did, unless I missed something, but
Well, even if we Let me see. Just want to clarify. Go ahead. You want to read that one real quick, MB?
Yes, so just want to clarify before the webinar ends, this will be included in the slides that are posted then. I think she's talking
don't-
back to
It'll be on the
um,
webinar.
to my
We're gonna
question.
post the webinar. Is that what you're asking? You can watch the Q&A
Well,
again.
I had suggested when I clarify how the license renewals will work, I could either give that information to you guys, and then when you post the
Oh,
slide
yes.
deck, you could provide that information, or I could email everybody. However it works, it will get to the people who would who want that information.
I think you can actually still put it in the chat
There you
post
go. Okay.
facto after
Yeah.
the meeting ends. And then
Yeah.
if you have Teams and you're using Teams out there, then that'll be part of this event.
I'll
And
do
then we
that.
can also share it via email if anybody needs it. And that's the thing. All of our emails are in there. If you have questions, shoot us an email. I will say email is the best way to get a hold of us with a legal type question, policy question, because we can read the fact pattern, think about it, and answer, be deliberative in terms of talking to each other, rather than trying to have a phone call and then end up just saying, hey, look, I'll call you back or I'll email you. So just shoot us an email as a general matter, best way to get a hold of us. My phone number is around on the internet and stuff. Text my cell phone is another good way to get a hold of me, but we are always open and ready to answer questions. So feel free to contact, and definitely ask first before you do something you're not sure about.
all right, we got one
Right.
more question. Do you want to
Okay.
field it? Okay.
Yeah, let's go ahead and answer it. Yep.
All right, this is from Bart Harriman. If
We definitely got to
alcohol,
answer it from Bart.
yeah, if alcohol is donated to a qualified organization with a permit or another permittee for a not-profit sponsored event, may the organization or retailer sell the product at the nonprofit event so long as the proceeds go to the nonprofit? And that's the last one in the question answer, if you want to read it yourself.
Yeah, I'm reading it. Thank you. Yeah, the answer is yes.
All right, I believe that's all the questions.
All right. Thank you guys. We really appreciate all your participation today. This presentation and the attachments, everything will be posted online. You can rewatch the webinar and I'm sure you're going to watch it 30 times. It's just so enjoyable. So we really appreciate you guys. Please reach out between now and the next session if you have any ideas for law changes. So thank you guys and have a great summer.
Thank you all.
Thank you.